Good morning. Good morning. Good morning, everyone worldwide. Thank you so much for coming to spend your Tuesday, July 30th with me. How is everyone? Am I live? Because I have my YouTube up on my phone. Oh, there's a very, very long delay. A lot of latency today on YouTube. Are we breaking the internet again, my friends? Good morning. Once again, today is Tuesday, July 30th, and we are in the final stretch of the Ashley Benefield trial out of Manatee County, Florida. It is expected that the state will start their rebuttal case this morning at 9 a.m. And then I think we have some housekeeping to do, maybe some final thoughts on jury instructions. And then this afternoon, we're going to hear closing arguments. So it's going to be quite a day. It's crazy coming off the Karen Reed trial, which was almost 10 weeks long, or was going into its 10 week when it finally landed or ended in a hung jury, to see a second degree murder case go so quickly, isn't it? It's crazy. It is crazy. Good morning, Lana Burns from Australia. Shot Daddy from yesterday runs a firearms forensics consultancy firm with his father, Lucian Haig, who was the gun expert in the Alec Baldwin and Hannah Gutierrez Rust cases. Yes, that is so interesting. I love that whole father-son business. He talked about that, how he's been doing it ever since he was a little kid, because his father apparently is a very highly regarded expert in the field. Thank you so much for the super chat, East Maine, and became a new member. Thank you and welcome. And thank you on top for always being on top of the super stickers first thing in the morning. Did anybody venture out into the wild of YouTube last night to see what's happening? On the other side of this, Ashley is guilty because I hate her facial expressions camp. Anybody go out there? I didn't. So let me know what you think. Yes, the state is going to recall Eva today. After we broke yesterday, they had some conversations with the attorneys regarding whether Eva could be recalled. And the judge said that she could. It was interesting, though. I don't know if you guys watched it, but he did say something like, well, she's been in here for most of the time, but actually not really. She's been in and out. So the judge did notice her kind of storming, if you want to say, in and out of the courtroom yesterday, which we noticed quite a bit. And the attorneys are coming in. We'll just put that small for now. If you do go over there, just, guide your actions accordingly when it comes to braving the chat. Good luck with that. So yes, they're going to recall Eva today. They wanted to introduce, they had some arguments over the pictures that they want to introduce, that modeling photo, which is kind of ridiculous to me because that photo, anybody who's ever had headshots taken or any sort of professional photography, those photos are so retouched and they use, special equipment. It's like they always make you look 100 times better in headshots and glamour photos. Remember glamour shots? They used to have that in the mall. You could go do glamour shots. So I don't really know what relevance that headshot is going to have for the jury. Something about a droopy eye, I think they're trying to show. But again, it's retouched. It's a headshot photo. It's on the internet. Who knows how many programs it's gone through, right? How many editing, retouching. And then again, the mugshot, which was taken over a month after the accident. So I don't know. Just seems I don't know how relevant it is. And then they're going to try to say the puffy eye is always there. Thanks, Mike. I was trying to figure it out. Then they had a photo of Eva and her dad on a boat. And Eva's going to take the stand to say that it was taken only a month before before Doug's death. However, and they're trying to say that he's not as, buff or jacked up as he looked in those photos. You guys, I got to take a call. I'll be right back. I'm going to put this on for you. Okay, I'm back. I'm back. What are they still scrolling at the bottom of the screen? Information about the medical, that the medical examiner says that he was shot from the, let me take a look at what it's saying. It says, I mean, how many times did we have to watch people pointing to the point on Doug's chest next to his right nippy, we decided to call it. To me, that's the front of someone's body, not the side of someone's body, the way that the prosecutor indicated in her opening statement. I can't read what it says right now, but maybe you guys can read it better than I can. I don't know why they're doing that. It's I don't know who they have. And why does it say starting soon? They have 3 O's in soon. They have an editor over there? Does anybody edit those captions? Look at that. Starting soon. It's starting soon. Oi. Oi, oi. Good morning, Shantae's Inferno. El Rose, thank you again for a safe place. I had to catch up on Friday from the pain clinic. I'm sorry about your pain. Worst doctor I've ever dealt with. I'm sorry. Absolutely no empathy. And to the administrative staff, he complained about a patient. I don't know. I don't understand. I mean, historically, doctors' offices have had people working for them that are not the nicest. And so when you find a doctor's office where the people are really nice that work for him, that answer the phone, they're the face of your firm. When I had a big law firm, the people who answer the phone at your firm are really the most important because they're the face of your firm. And if they're not nice to your clients and or your patients, then your clients and patients are going to go somewhere else. So that's unfortunate. When you find a doctor who's got great bedside manner and a great office, stick with them. I've had my primary doctor for something like 30 years, and I'm very loyal to my doctors. I never leave because once you find good ones, gotta stick with them. We did, yeah, that's right. They will have the autopsy photos. We did not see the autopsy photos, but we did see many, many witnesses point to the part of their body where they say the gunshot wound to his chest was entered. How can they say that that's not the front? Wouldn't that misrepresent the evidence? Well, the prosecutor, if you were watching yesterday, had the medical examiner, one of the witnesses, stand up and to indicate that it was kind of like went into the side of his chest, but it's the front of his chest. So there's been conflicting testimony about that. In any event, he was not shot in the back like the mainstream media wanted you to believe for however many years it has been since they've been covering this, because this has been going on for almost 4 years. All right, taking bets already. Who's the bookie in the chat? Ramblin' Rome says I say not guilty in under 2 hours. We'll see. We're going to see what the jury instructions are too, because how likely it is that we'll have a verdict today. I don't even know if the jury's going to get the case today. They've each been allotted an hour and a half for closings, although they said they're probably not going to use that much. Judge indicated he may send the jury to lunch early. So let's say if they come back at 12:30, 4:30, will they charge the jury today or will they charge them in the morning? I'm not sure. They may charge them today and then let them start deliberating in the morning. I don't know. We'll see how fast they go. I don't think the rebuttal case is going to be very fast. I mean, very long. I'm going to find my words eventually, I promise you. Not enough coffee yet. There's the hotline on the bottom. Anybody who may need it. I don't think the rebuttal case is going to be very long. They may only be calling Eva. Good morning, Nurse Kimberly. Good morning. Good morning to Australia. Alan and to Kasha in Norway. Good morning. Bernadette says online photos don't have a droopy eye at all. Oh, if anybody watched it yesterday, what I thought was so interesting was that the prosecution said that they just found that photo of Ashley from the ballet, that black and white headshot, like yesterday or something, or like this week. Okay, people have been posting that photo online for as long as this case has been going on, since she was arrested. So for them to, it's a little disingenuous, I think, for them to say, "Oh, we just stumbled upon this photo on the internet this week." Come Come on. Joanna says, I'm terrified it would be a hung jury. The Karen Reed trial gave me PTSD. I thought then it would be under 3 hours for not guilty. So did I. I was in the 2.5-hour camp myself with Karen Reed because, in my opinion and in my professional experience, John O'Keefe was not hit by a car. So I didn't understand. Still don't understand. Hello to the UK. Hi, Linda. Good morning. Exactly, Cynthia. They're going to have, I don't know what relevance it has either. They're going to try and tie it together, I'm sure, in their closing. And they're going to say, look, her eye is always this way. It didn't happen that day because he punched her in the side of the head. It's always like this. It's always been like this. So I don't know. Central Florida mommies, I have a bad feeling she'll be found guilty based off of the 3 shots fired. I mean, the question is going to be, was she in fear for her life or great bodily harm in the moments leading up to the shooting? And if the jury finds that she was, under the law of the state of Florida, she's allowed to use deadly force. Stand my ground law. She doesn't have to retreat. Good morning, Amonte. I guess they call Eva in order to create sympathy. I would not be surprised if Eva cried today. They were actually admonished. They were said, you're not, or they're not admonished, but warned that they said, you can't call her just for sympathy reasons. I don't want you having her get up here to say, oh, I really miss my daddy or anything like that. Because, so they had this photo of Eva and her dad on a boat. And they're saying it's a month before the accident. He's got a shirt on, so you really can't tell what he looks like underneath. And they have him standing next to Eva, and they didn't really show us the photo, but it looks like they're kind of around the same size. I don't even know if it was a full-length photo. And so the defense objected and said, well, we don't want her standing in the photo next to him. And they said, well, she was 15 years old. And he said, no, she was 19 years old, number one. And number two, what relevance does this have? So the judge took a pair of scissors and he cut Eva out of the photo. And he said, here you go. This is all you can use. So he did cut Eva out of that photo that's going to be allowed into evidence. And the other thing is that when the prosecution introduced those photos of Ashley, when Ashley was on the stand, they had her look at them, the mugshot and the modeling photo, but they didn't move them into evidence. You know, there's a procedure that you need to follow. You need to have the witness authenticate them, and you have to move them into evidence in this jurisdiction. They're not automatically in evidence, and they never did that. And they're saying, well, you know, just kind of an oversight. And the judge allowed it. I'll allow it. Oh, Sonia, thank you so much for tuning in from Portugal and for your always very generous super chats. And how beautiful is it in Portugal today? So jealous. She was waiting for me. Thank you, Sonia. Thank you, Sonia. Love and prayers from Portugal. Prayers up for everyone in the chat, for Ashley, and for the Benefield family, and for Eva. Eva's lost both her parents. Let's see who we see coming in the courtroom. Spectators are coming into the, yes, Mother of Eagles. You did watch it afterwards. The judge old school cropping photo was hilarious. He just took out his scissors, cut her right out of the picture, the way like when you were in high school or junior high and you would cut your old boyfriends out of the picture because you still liked the picture. And the prosecutor was like, well, I can, do this professionally on my, printer and enlarge it. And he's like, no, I'm cutting it here. Here you go. It's pretty funny. Terry says he was a martial artist. Size doesn't matter. Right. And also, some people pointed out yesterday in the comments that if he was approaching her from like a martial arts standpoint, he would turn sideways to make his target, I think they called it, or the body mass smaller. So it would be a smaller target for her if he was trying to disarm her. If that makes sense. If anybody can verbalize that better than I can, feel free, because it's still early here. Oh, thank you, Kimberly Tony, for becoming a new member. Welcome. I have sympathy for Eva as well. Harmony says, I'm not thrilled with some of Eva's behavior, but I do have sympathy for her. She's young and she's lost both parents. I give her some grace. We have to. We have to give her grace. Listen, this is her generation, that generation, our kids' generation. That's what they do. They go on TikTok. They make their videos. That's their thing. That's how they communicate with the world, with everyone. That's how they talk about their feelings. So I can't fault her for that. I just wish somebody had prepped her a little bit better. about, and maybe that's what they said to her. They said, listen, if you're going to start making facial expressions and the cameras are going to be on you and you feel like you can't control yourself, then please leave the room. And maybe that's what she's been doing. We don't know. Good morning, Angie. Do we know if Doug's family tries to see Emerson? Hope she stays safe regardless of outcome. I don't know. I do not know. I did see that cousin Tommy with an IE was on court TV again last night. Every night he's on there. And like I pointed out yesterday, Tommy, if you and Doug were so close and he was like closer to you than your brothers, how come you didn't know about Ashley for 8 months? You didn't even know who Ashley was when you were in town and called and said, can we go to dinner? And Doug said, oh, yeah, but why don't you come here because Ashley's not feeling well? And Doug said, Tommy said, who's Ashley? So begs the question of how close Doug and Tommy really were. And would Tommy have even known a side of Doug that he probably, likely, almost positively didn't show his entire family? That it was a different persona that he had if he was indeed using this wheel of power and control over Ashley, as many of you believe that he did. Victims, survivors of abuse don't usually tell people what's going on because there's a lot of shame, guilt, embarrassment involved. How did I get into this situation? I'm smarter than this. And there's a really weird trauma bond of Stockholm syndrome, and you still love the person and the highs and the lows and hoping it's going to get better and hoping that the apology is going to be genuine this time. And we heard all about it from that Bruce Ferris, who I thought was an excellent witness. I think he should teach everyone about the dynamics of coercive control and DV. And I thought he was a great witness for the defense. You picked the wrong Benefield, said Cammie. And that's what Doug said. We watched those text messages together. We read them. Here comes Ashley and her team. And many of you and I were of the opinion that Tommy was trying to hit on Ashley, reaching out to her even after the orders of protection were issued. Yannetti Spaghetti, good morning. Good morning, JD Lyon. Krav Maga 101 is making your center mass small and attack the arm to disarm the opponent. Also, good morning, everyone. Thank you, JD Lyon. That's exactly what I was looking for. You read my mind. Here comes the judge. All right, well, I have my volume on, so as soon as their volume comes on, we will be all in on this. Thank you so much, James, for the Cash App today. You are amazing.
All right, good morning, everybody. We're back on the record in state of Florida versus Ashley Benefield, 2020 CF 3014. I have both the state and the defense here along with Ms. Benefield. Is there anything we need to talk about, state, before I bring the jury out?
No.
Mr. Taylor?
No, sir.
All right. Are you ready? Are you ready to go? Do you need another minute or are you okay?
I'm ready.
All right.
Thank you.
Well, let's go and bring the jury in.
Yeah, after watching them yesterday, everybody was coughing. Nobody's feeling well in that courtroom. I wasn't feeling so well last night. It's like I was having a sympathetic cold, along with Neil Taylor, watching from Alaska. Good morning, Alaska. Good morning. What time is it in Alaska right now? ERP, Thompson Queen. Are you on California time? Thank you, One Juror Matters, for your lovely compliments so early in the morning. I don't know if Jules is there. I think this is a different angle than we usually see. So I think that Jules is to the, yeah, if she's there, she's to the side of that man in the turquoise shirt. I think it's just a different angle. Good morning, Venice, Florida. I don't know the answer to this. Maybe somebody in the
Sorry,
chat
you all can have a
knows.
seat. Good morning, everybody. Welcome back. Before we get started, did anybody talk amongst yourselves about the case, discuss it with anyone else, or do any research about the case? Nobody says no. All right, when we were finishing up yesterday, the defense had rested its case. The state, if it wishes, can present a rebuttal case. State?
Judge, just very briefly state and call Eva Benefield.
Okay, Eva's taking the stand. I don't see Jules either today. And I didn't ever hear the defense officially rest yesterday. That's why I was confused, but apparently they did.
Same rules as last time. Just make yourself comfortable. Get about 12 to 15 inches away from the microphone.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
When was that picture taken?
That was taken in 2018.
Who took it? How does
Then
she?
I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Judge, I just want to publish it briefly. Oh, at this time, I would enter State's Exhibit 105 into evidence.
Same objections?
No objection.
No objection. Received.
Yes, Teresa. I just thought he would do it like formally in front of the jury for some reason, like defense rests, like, you know. So I think you're right. But he said it outside the presence of the jury. Ashley said that picture was taken in 2020. The shirtless photo or the jacked up photo on Facebook that we looked at, I think.
Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
Okay, again,
Give me a call,
right.
Mr. Taylor.
No question.
Can the
Again.
witness be released from her subpoena?
Yes.
Can the witness be released?
hold on. I just want to take that back a second to freeze that on the frame. Okay, so here's the picture that they want us to think was taken closer to the time of the incident. And he's not pumped up. He's not at the gym. He's got a shirt on. I'm not sure how that helps.
Questions?
I mean, if they're trying to tell
Can
the jury
police
that a
use
woman
subpoena
should not be
to
afraid of a man who may be
All
the
right.
same height as she is.
All right. Members of the jury, at this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, do anybody want to be heard before?
People are asking in the chat, why was, if I could find that question. Eva was under sequestration, but there's a law called Marcy's Law, M-A-R-S-Y, Marcy's Law in Florida, that allows the next of kin the right to sit in the courtroom during testimony, even if they're under sequestration. And remember that she gave an interview to a reporter in the hallway, and then The defense tried to keep her from being recalled because of that. He said she was in violation of the sequestration order, but the judge reserved his ruling on that. And then yesterday they decided she was going to be allowed to come in just for this limited purpose and testify. And again, you're right. They kept Ashley's mom out of the courtroom, saying they might recall her. They didn't. I hope she's allowed to come back in now. And I hope she's able to give her some comfort, because she has really just some friends and pastors with her in the courtroom. I'm sure she would love to have her mom there. And yes, Connie Thomas, how does that picture determine his strength? I don't know. I just don't think that that's a great message to send to the jury. Tell me what you think.
So what I'm going to do is give you a break. If I could have you back downstairs at the jury assembly room at 12:30, and then we're going to get you rounded up and get you back up here and get going with, if you remember, it's going to be some initial instructions by me on the law. The attorneys will have a chance to give their closing arguments if they wish. Then there'll be some final instructions, and then you'll begin deliberations. So remember, now that everything is done, please remember the rules. Don't discuss the case amongst yourselves until all of those things are done. Don't talk with anyone else about the case. Please don't do any research or watch any coverage about the case. All right, so we'll see you back downstairs at 12:30. Thank you.
Harmony says Jackie Chan is 5'9". Look at the damage he can do because of his training. Agreed. People are asking why then Ashley's mom couldn't be in the courtroom. Marcy's Law protects the victim's family, not the defendant's family. And in this case, Ashley is the defendant, not the victim.
Kelly handed me an email from the state with, I haven't had a chance to look at it yet.
So you have a printed copy?
I do. I have to print out a copy for me.
What's I emailed last night?
Yes. All right, so
Not the treasure.
I assume that this has all of the changes that we discussed yesterday.
Yes. To the best of our ability, yes.
All right. So let's go ahead and take a run through these. And Ms. Benefield, please feel free to share a copy with your attorney, look over his shoulder. So Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir. Thank you.
All right. First, 3.1, any objection?
No.
3.2, statement of the charge, any objection?
No.
7.1, introduction to homicide, justifiable, and excusable.
No objection. You have to the second part under great bodily harm. Means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I object to that part. I think particularly because of the nature of the facts in this case.
Point out to me what you think they're trying to prove by whether Doug was right or left-handed, if you know.
Judge, we'd be asked that it be read on editing.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event. I think to keep this instruction as it is to the distinct detriment of Ms. Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
All right. I understand your argument. It is part of the standard jury instruction. It's not misleading in its nature in describing great bodily harm. It complies with Florida law and the statutes. I think it needs to be given as part of the standard instruction. So I'll overrule that objection. Other than that one, the rest of it looked all right?
Yes.
7.4, murder in the second degree.
And it's the state's position that that part in yellow about sudden provocation should come out.
Judge, I'm sorry. I just wanted to also mention in the May update to the jury instructions, they cut out the reference to mere bruises.
No, well, online, it still has on the.
Do you have the Florida Supreme Court order on that?
I'm on the bar website, so.
No, defense. Do you have there'd be a Florida Supreme Court order. Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update.
Yeah, right there.
I may have it, Judge. Give me 1 second.
This is jury instructions.
Yeah,
If you're
I'm
just
gonna have
tuning in, good morning. Both sides have rested.
The Florida Bar website still does not include mere bruising.
Okay, you're a judge.
Well, you showed to the state first.
Well, this is a different instruction, sir. This is not homicide. This is justifiable use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use or threatened use of deadly force. Court will note that mere bruises has been redacted.
Yeah, the paper crumbling is annoying, but at least we have good microphones this time. In many trials, we were scrambling to hear it all, so what are you going to do? Marta says the right-handed proves she was hit on the correct side of the face. Right-handed person hits another one on the left side of their face. It's all proved to me. I thought she was hit on the left side of her face, too. Thanks.
All right, thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024. That was not the parts that were amended. On 3.6.
All right. I appreciate the argument. It's a standard jury instruction. It's not a misstatement of the law. I'm going to give the standard. All right, 7.4.
It's okay.
The judge, it's the state's position that there's been no evidence of sudden provocation. I'm sorry, heat of passion, inadequate provocation. There was no evidence that a reasonable person would have lost normal control. would have been dropped. There was no evidence of a blind and a reasoning jury, so the state would ask that that section be removed.
I
Do you
disagree.
want
It's a
the
question
sudden
for the jury.
provocation?
She said, I don't want you to
Towards the
come.
bottom
He
of
said,
7.4, going to the second page.
you're effing done.
I'm fine with it like it is.
So you want it in,
Yes.
and state you want it out?
Yes, I don't think there's been any evidence that entered to go to those facts. That portion.
He chased her around the house and blocked her from leaving. I disagree. I wish there was a way for me to pull up two screens at once so I could show you this instruction, but
All right, I'll leave it in.
good. That's a win for the defense.
3.3G, possession firearm.
Fine.
State.
Felonies.
3.4, lesser included.
Fine.
7.7, manslaughter.
Fine.
3.3A, aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6, justifiable use of force.
Yeah. Which one? Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6. Pay attention.
3.6F,
Oh, okay, that's what I thought.
I wonder if the court would consider under the second part, giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
all right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender to the court.
Well, this is the final charge conference, so I'm going to need it.
Jury instructions are so important because even if the jury doesn't find that she was a victim of DV, they still could find that she used justifiable force.
Okay, here's one that we had, Judge, in preparation. I'm trying to keep up with all the paperwork.
And just because a jury could find that she was a victim of DV, they still could find that she was not justified in using reasonable force. So both things could be true. I know, Gigi. I notice her rolling her eyes too.
Your Honor, I'd also like to request, if we could, adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Immediate.
I think it might come from case law.
It says it comes from Webster's Dictionary.
Sunny in Wales today, says Mandy.
The state objects. Number one, that the definition does not make sense to the state. Number two, I'm on Webster's Dictionary where it says it comes from, and that is not the definition provided by Webster's Dictionary. It's partially, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was his second request, which it's in the second paragraph. Great bodily harm means distinguished from slight, trivial, minor, or moderate harm.
I think imminent should be defined because it may have a legal definition than the Webster's dictionary.
That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Under 3.6F, the second paragraph, where it defines deadly force, means force likely to cause death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's got a definition of great bodily harm.
No, it's not.
And actually, my copy has an explanation.
Right, it's
That's the standard.
from the standard.
Okay.
And then it was you asked for imminent, you made your arguments against it, rebuttal.
The rebuttal, other than I don't see what the downside is to it, I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in. So let me mark it for you.
Tell me in the chat what you believe the definition, and don't look it up, what you believe the definition of imminent to be.
Preserve. So this is defendant's proposed definition of imminent.
Okay, a lot of people say immediate.
See the 30th. All right, that'll be filed.
And Judge, I think we got ahead of ourselves in this instruction. So if we could go back under the paragraph on 3.6F, the first page, it says the law and justifiable deadly force. Use of deadly force is as follows. It's the state's opinion that first section in yellow would come out because of where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and is almost identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed late yesterday. So
Yes.
You're in agreement?
Okay.
Yeah.
All right. So
I'm sorry, Judge, I didn't realize we made a decision on that.
Well, I don't think we made a decision. I just rambled on and on explaining the difference between the two and the distinctions and why 7760122 and 7760312 differed than 7760131, but covered the same ground. Just one is general self-defense and stand your ground, and the other one is in your home.
All right, I'm just going to pause that for a second. So this is interesting because the Oxford Dictionary defines imminent as immediate, and the Webster's Dictionary defines it as ready to take place or happening soon. So that's happening soon is not necessarily immediate, right? Because your version of soon and my version of soon could be two different things. So I find that to be interesting. Imminent to me, I always thought of it as immediately, right? More than likely to happen immediately. But under Webster's, it's happening soon. So that's interesting.
And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law on just to if she's in a dwelling, that portion.
Right.
Some people thinks that it means very likely,
All right, here's where we're going to
as
need to
opposed to a
take a few
time.
moments to talk about the forcible felonies. And Mr. Taylor, I had written them down yesterday. Hopefully you saw, oh, there it is. All right, state yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776-013 subsection 1, I assume that you're going to want A and B?
Yes.
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Correct.
Are there any others?
No, sir.
No felony battery. I thought felony, did you say felony battery?
Mhm.
Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge, sorry.
Burglary, ag felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours, but I'm not sure yet on that one. So
Okay, well,
I just think there's problems with each one of them, and I'd rather if we could just go through them.
Okay. Burglary.
I think it's a classic remaining inside. The testimony, if the court recalls, from Ms. Benefield was that when he spun her around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present, and as a result, at that point, he was a remaining inside burglar.
so what they're talking about now, the burglary, the false imprisonment, are crimes that he could potentially have been committing against her, which provoked her reaction. See what I'm saying? These are not with regard to her, they're with regard to him.
All right, well, that's not just the end of it. So I've got the standard instruction for burglary,
But I
which
need to
would
hear
need
the
to be
instruction.
obviously modified because I don't instruct them on the burden of proof. It's just the elements for any of these forcible felonies. The initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary, under 2, there's 2A, B, or C, so I need to know which one of those you're arguing. And based upon what you just argued, I'm assuming that you want 2B, as in Bravo, after it, that would be essentially 2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn and with the intent to commit, there has to be some crime alleged, right? Because it can't be
Assault.
burglary or trespass. Or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Give me a moment.
I wish he was in fear of assault.
Yeah. I think we would prefer other than, Your Honor.
Thank you, Emma.
All right, State, now it's, and are you asking for any other portion of the burglary statute if it's to be given?
Give me just a minute, Your Honor.
Thanks, Laura, for pointing this out. Laura says, when I was a juror, the instructions tied our hands. Acquitted, had to. Right. We're a little bit behind.
It was down.
Okay. All right, what was the court's question?
On the burglary instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
Shabani coming in with facts. Says many people that don't support her and believe his family side say all the things she could have done. I point out there are things he could have done, like leave when she retreated to her room. Right. She asked him to leave. She said, we're done. I'm tired. Can you go? And he said, you're effing done. And he cornered her in that little tiny room. He chased her in there too. People are saying, oh, she lured him into that room because
So
that's where she had her gun.
I just want to make sure we're talking about the same thing.
No, so
Maybe or C.
the court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep. And then I have to give A, B, or C
Okay.
as appropriate. And I'm sorry, that's A, B, or C. Can be in the conjunctive or the disjunctive.
All right, we would request B and C, Your Honor.
I would agree that I don't like their style, Molly. It's a style. Catch more flies with honey, you know?
All right. And on C that you're requesting, is it just to commit or attempt to commit a forcible felony?
Yes.
Which potentially will be.
You're-
Now, any other portion of that instruction before I go to the state?
DeBear, Dancing Bear, good morning. Dancing Bear says, I'm sorry, I don't know if the defense proved their case. There are some areas in this case that leave some questions, except the defense does not have the burden of proof. The defense doesn't have to prove anything at all. It is the state's burden to prove beyond a reasonable doubt that Ashley did not act in self-defense. When a defendant invokes self-defense as an affirmative defense, the state has the burden to prove that it was not self-defense. I know it sounds weird, but that's the standard, and that's the way the jury's going to be instructed, and that's why jury instructions are so important. Thanks, Dancing Bear, or D-Bear. Maybe it's not Dancing Bear.
Over to you if I do decide to give it, if there's any additional portions you prepared to argue those.
I agree, Julie. She did retreat, and she doesn't have the duty to if she's in imminent fear of imminent bodily harm or death.
That's it, Your Honor.
All right. Okay, that's it, state. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yes.
So it's on the second page.
Yes, sir.
And if I give it, it'll essentially be something along the lines of the elements of the forcible felony of burglary are 1, 2, B and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, there'd be an or. C, commit or attempt to commit a forcible felony. So obviously you object to that, but if I am going to allow it, is there any other part of this instruction that you would want to be given?
2 paragraphs. Oh, let's see. It says the next paragraph is about intent being an operation of the mind. The following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it. If the evidence does not establish that it was done with the intent to commit a crime, other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because I know we don't have proof, but I think that is an important.
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next 2 paragraphs to be given, which explain intent. And I only had, when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
All right, so here's what I propose it would sound like, and everybody can object, because you don't want it, you want it, but you might not want like the language, but I've given it before and it works. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Here's where the changes are because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it's an accurate, I'll hear your arguments, but I found that it's an accurate statement of the law, because the other way is the defendant must be found not guilty. That's not what we're talking about here. So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us.
All right. Do you need that, State?
I will need that. And I can say, based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
We'll need to.
Oh, I'm sorry. And we also need structure, because structure is not defined in any of the other instructions. And that's on the very next page.
No, you should define imminent
Mr. Taylor,
too.
what I've done is I took the standard instruction and have amended it in my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right, thank
Does
you.
that include the elements portion too?
And this is what a lot of people think. Plum and Dunn, not to put you on the spot, but I'm going to put you on the spot because you wrote it in the chat. Says, I'm sorry, but I don't buy it. She's trying so hard to look frail and sad. Something's wrong with her. I'm glad that you came into the chat today, because there's so many survivors and victims of DV in this chat that maybe could help you understand why she looks that way, why she was shaking uncontrollably during her testimony, why there were some responses physically in her body that you just can't fake. So hopefully some of the people here can kindly explain that to you if you've never been a survivor or a victim of any kind of coercive control or emotional and physical abuse. You're very, very lucky, but a lot of people in this chat have experience, and I think can try and maybe help you understand. I don't think she's trying. Oh, well, I'm going to let them respond, and you guys can have a dialogue respectfully.
Yes,
Okay. Sorry, I was trying to do it
Yeah.
as you were talking, but I wasn't keeping up.
my penmanship is horrible. I
That's fine.
apologize.
This is perfect, Judge. Thank you.
All right. So that's what I've approved for burglary. Let's talk about false imprisonment next. And that's instruction 9.2.
Judge, I had one thing before we leave. On the last portion of 3.6F, justifiable use of deadly force, I wanted to ask the court to substitute 2 words in the final section.
I don't think we've gotten there yet.
We've not gotten there yet.
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah. So the next forcible felony that the defense has requested is false imprisonment. So 9.2. If I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are. So which one of those elements or methods by which one is falsely imprisoned do you think the evidence supports, Mr. Taylor?
We would like to have confined and restrained.
Just those two?
Yes, sir.
Okay. And also on number 1, you would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
Forcibly.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about forcibly and by threat, Judge?
So it would be or. And that means we would not need secretly. All right, state.
The state would object. There's no evidence at the time in which Ms. Benefield used deadly force that Mr. Benefield was preventing her from leaving. If there
Okay,
was
that's-
a time in which,
I mean, the defense doesn't have to prove anything, but if they did prove anything, it was that he prevented her from leaving by blocking the door, by kicking the door open so she heard it slam inside that little tiny room that we looked at the 3D laser scanner video of yesterday and prevented her from leaving. That's the one thing we actually did hear quite a bit of evidence about from the defense. So I can't believe she's arguing this right now, but she's gonna.
there could be argued a false imprisonment, it would have been when she tried to get out the door and claims that he spun her around by her arm. But there was no evidence that once she was in the bedroom, there was any effort to forcibly or by threat confine or restrain her without her lawful consent, so the state would object.
What about your effing done? Does that count? What about his eyes being black and looking at her and saying you're effing done and going into a fighting stance in the bedroom? Does that count?
Rebuttal.
Well, actually, I believe the testimony was that when she turned around, he was standing in the middle of the doorway,
We listened.
blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However, the facts as presented by the defendant do support the giving of this instruction. False imprisonment, here's how it'll read. The elements for the forcible felony of false imprisonment are Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so. That would be the end of that instruction.
And that's a good instruction, because if the jury finds that to be true, they may find that she, in her mind, was in imminent danger of bodily harm or death, right?
I review the rest of it. The rest has to do with certain enhancements.
Are you giving me that one too? Are you gonna give me that one too?
I would ask.
If not, I'm gonna need you to repeat it.
Yeah, no, my plan is to, after I do this, give them to you, because then it's all,
Yes, sir. Thank you.
I'm sorry to put that on you, because I know you're objecting to it, but,
It's on her. It's on her.
all right. Anything else on false imprisonment? So I am going to give it as I just read.
And
Okay. Yes, we would request a specific definition of the term false imprisonment based on the case law Proco versus state, if I may.
A definition of false imprisonment?
Yes.
the elements are there.
Isn't that the elements of false imprisonment is the definition of it?
This just lays it out, Your Honor.
Okay. Go ahead and take a look at it real quick. State. Thank you.
Right, that's something else we haven't really talked about, how cold it is in that room. When Jules called in yesterday, she said it's freezing. That's definitely going to affect someone's appearance, demeanor, posture.
All right, did you want to be heard on this?
We object.
All
I
right.
think the elements are sufficient.
Any further arguments?
No, sir.
All right. I see where you pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute. But I don't think I would give a definition of false imprisonment in the false imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
All right, so let me do this. Same thing, it's just my marked up version that I'm going to give them so they can, that way the typeface will all be the same. Thank you. For
Thank you.
instruction in false. Where to put this? There we go.
Oh no, Jules is not in court today because she's not feeling well. When she told us, yeah, I thought so. There's too many sick people in there. I was feeling sick, Jules, and I wasn't even there.
How about aggravated battery next? I'm trying to take them in some
Feel better
semblance
soon.
of descending order. Might not be perfect, but all right. Ag bat. So I guess what I'm looking for.
Good morning, Cheryl. Thanks for the 10. Huge point missed here was that this was the most potentially lethal stage of the abuse cycle. Most murders occur after the victim leaves the abuser, hence why he became physical, losing his control. Excellent point. I think the expert verbalized that for the jury, and I'm sure that the defense will tie that together in closing. Thanks, Cheryl, for the 10.
Defense from you is what parts or portions of aggravated battery 8.4 you're asking for. It would start with Doug Benefield, A or B under number 1.
Judge, I think, frankly, after reviewing this instruction, we're going to withdraw the request.
Okay. So ag bat is withdrawn. Next one is felony battery. 8.5.
Yeah, we're going to withdraw that as well, Your Honor.
All right, felony battery is withdrawn as a forcible felony. And the final one that you had requested was 8.2, aggravated assault.
That seemed to be.
How does that look?
Well, there's a brief break. Everybody check your phones. Make sure they're on silent or turned off.
This
please.
one, I think, is viable.
You want to keep?
Yes, sir.
All right. And so let's look. There are some options, so let me go through them. So 1 is standard, 2 is standard, 3 is standard, but then under 4, are you asking for A or B?
B.
And what is the felony charged? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others.
They're getting it, but I don't think that there's evidence that he made threats by order act, I guess, other than you're done, which the state would argue is ambiguous. At the time, the defendant Mr. Benefield appeared to have carried out the threat. I don't know what that means for this case, and the defendant created a well-founded fear of violence was about to take place. I mean, I think this is so akin to the self-defense argument that I think it's duplicative, but also to then say that assault was made with a fully formed conscious intent to commit false imprisonment against her. Their argument was just that he was already false imprisoning her when I don't know how you would put this in there, Judge, because he was already committing a false imprisonment, and then when he made the threat, he was then fully informed to commit another false imprisonment. I just think it's circular.
Change
and
it.
I'm not sure that it will make sense for
Assault.
the jury. I think it'll be confusing.
Like most of these things, it becomes a question of fact for the jury. And I'm not prepared to say precisely when, given those facts and the fluidness of the circumstances, when or for that matter, if the jury will conclude that there was a false imprisonment.
All right, thank you both very much. I'll give it. The question is, any other portions of that, or it's just the elements of that one? Certainly, there's no deadly weapon.
Or B. I think the first one, if the circumstances were such, that should be in. Deadly weapon is out, as would be an object not designed to inflict bodily harm. Great bodily harm is out. As would be, Judge, not necessary that the defendant had an intent to kill.
Okay, you give this one to the state. So that'll be the last one. So we ended up with 2, right? 3.
And I guess, Judge, I'm gonna need some guidance on how to word this. Imminent commission of forcible or burglary, false imprisonment, like that sentence isn't gonna make sense.
I'll give that to you.
Thank you.
All right, so I think it would need to say
imminent death or great bodily harm to herself, or the imminent commission of burglary, false imprisonment, or aggravated assault against herself.
Okay.
It'd be in the disjunctive. And then immediately after that, I'll need,
Those in order.
yes,
Yes.
thank you. All right, the next portion of what we need to discuss on the self-defense, we're still on 3.6F. We're through the use of force in the home. The very next paragraph talks about 782.02. This is the bottom of the second page of the state's, I think it's on the bottom of the second page.
I thought I took it out.
I think we talked about yesterday removing that, but let me make sure. The portion about 782.02.
I think I already took it out though.
I thought we did, but I have a question mark next to the one on my copy.
Oh, okay.
So I'm just making sure.
I have the next, just for clear, the next paragraph I have after the ones we were just discussing is in deciding whether Ashley Benefield was justified is the next paragraph I have on the one we did last night. Is that what you showed, Judge?
I look at the one.
I thought you had asked yesterday if we wanted A and B.
Justice Scales, 1, 2, 3. Opening the door doesn't prove preventing her from leaving. Fighting stance has not been proven. Stick to the facts. How do you prove things outside of testimony? The jury is the finder of fact, and the jury is going to decide the facts here. So are you telling me to stick to facts? Because that's the facts that were brought into evidence, according to Ashley. So it's up to the jury now. But thanks for your thoughts.
We said yes.
That's how we're talking about.
On which one? I'm talking about the portion that was 782.02. And like the state said, I have it, we weren't going to give it, but then I have a question mark by it, so that makes me wonder if it was, we're not going to give it, but we're going to think about it.
Yeah, I marked it out. I have it. I could. And
Again, I think that's what it is, but this could be just me having a question mark there for, I don't know why. But I just want to get confirmation on the record that we're not giving it.
Yeah, we'd like to have a judge, and we would request B and C.
All right, any further argument?
No, Your Honor.
no.
In response to the court's question, did I have any further argument?
Okay. So what before I go to the state, because this is my question. If we're giving 776013 that talks about the approved or justified use of deadly force when one is in their own home or in their own residence or dwelling house, including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing. What are we gaining by adding 782.02? It seems duplicative to me.
It wouldn't be the first time that there's an instruction that overlaps.
All right, state, you want to be heard?
Yes, Judge. It's not an instruction that overlaps. It's repeating parts that are already in the instructions. The first paragraph is in 7.1, justifiable homicide, that almost the exact paragraph. And I believe the state's contention would be these are cases that are not when there's been a homicide, so you wouldn't have read 7.1. That's why it would be in self-defense when you use deadly force, but it's not necessarily homicide. And so, and I think that to say B and C, that is exactly what you've already just read. And I do think it's duplicative, and I think could be confusing and we don't.
All right, final thoughts.
Nothing for
I think I've shown that I tend to give instructions when they're lawful, they're an accurate statement of the law. The facts of the case support the giving of the instruction, and it's necessary to explain or clarify an area of the law to the jury so that they can do their job. However, when you look at what's being proposed under 782.02, that portion of the instruction, it is, while a different order, it's virtually identical. Subsection C talks about the.
Hi, Lizzie. It does flash up. I just don't always stop the stream to answer the question. So if you have a question in here now, I'll go to it. Was all this done in the Karen Reed trial? It was, but not really to this extent. And a lot of it was not discussed in open court, but they did have, I remember a conference where they did discuss the jury instructions, and still in the end, they were found to be, in my opinion, so incredibly confusing. But I do remember them arguing about certain verbiage that should be in and out of the Karen Reed instructions, Lizzie. So thank you for that. Usually I don't like to just put them up on the screen without addressing them. So that was your question. And actually that one would have made sense to talk about at any time because I was going to talk about Karen Reed after we were on a break here. But thanks, Lizzie, for the super chat.
The commission of a felony upon Ashley Benefield in a dwelling house in which she was present. And that is taken care of in the instruction we're giving from 7760131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she's justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given. And so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So quite frankly, we're already giving that. That wouldn't just be duplicative. It would be the exact same instruction being given twice. The 776.013 subsection 1 covers all of the issues and elements that have been presented. All right, the next one is then in deciding whether Ashley Benefield was justified. Certainly that's in.
Yes, sir.
And then we discussed yesterday, all of that middle part is out. And then the last portion
Yeah, Judge,
Yes.
they've added, if I'm not mistaken, they've added totality of circumstances to that paragraph.
Which paragraph?
In deciding whether Ashley Benefield was justified in the use of deadly force, you must consider the totality of the circumstances.
It says you must consider the circumstances of the time
And
the force was
they've
used.
struck by which he or she was surrounded. So totality of circumstances at the time.
Terry wants to know why it's okay to define intent but not define imminent. That is not the imminent that they're talking about. There's another spelling of imminent. It's IMMINENT. There are two different, what do they call those? Homonyms when they sound the same but have different definitions. Judicial discretion. That's why, Terry. Thanks for the super chat.
Sorry. If you just show that to the state first.
Thanks, Bianca.
Those are proposed, that is not what happened. It's online is what happened. Those are proposals. We didn't strike it. If you look at 3.6 as the Florida Bar has it, it's the same. That's the proposals to the subcommittee.
So we would like the proposed language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission, it was when they proposed instructions
Yeah,
before they
this was from the committee.
So the committee proposed putting in totality of the circumstances, but it wasn't adopted.
Correct.
Okay, I got you.
We would object.
As the
Object.
court knows, the court's not married to the patterns any longer.
All right. Thank you very much for the argument. I think the standard jury instruction that we're dealing with adequately explains the law. It's not a misstatement. It's not going to mislead the jury in any way. So I'm not going to add totality of the circumstances. The jury is told you must consider the circumstances at the time the force was used. So I think it's sufficient. So that remains. And then if you look, then all that middle part is out. And then it goes to, if you find that Ashley Benefield, who because of prior threats or difficulties, had reasonable grounds to believe. Do you see that part?
I already took it out on the version I did last night, Judge, so it might be, I think he's working off the state's newer version. I took out everything you had already said.
Right, all that middle part is out. So it's going to go from, you must, look at the circumstances that she was faced with. And then it has the part about, you may consider and you should consider those prior threats and acts of violence that she knew about or was aware of.
Mm-hmm. So now I had on the penultimate paragraph.
Yes, sir.
Penultimate. There's a word we don't get to use very often. I'm going to work that into my everyday conversation. Got to keep breaking because it gets a little boring, but they are discussing it. It is a very important part of the case. Wendy Darling. Thank you, Wendy Darling, for the 20. Says, if you've never been a victim of DV, I don't think you can say how you would act. Abusers can be so sneaky and insidious. I'd say it had never happened to me. It did. Be kind until all the facts are in. Got my cup. Oh, you got your come from me in the cupcake tea today? Yay, yay, Wendy. Okay, whoever can name the movie from which Wendy Darling was taken, from which Wendy Darling is a character. If you know, you know. Cheryl Victor, thanks for the 10. Being a survivor, I cannot fathom using a gun on my abuser, but that's why I never purchased a weapon. I was afraid I'd have to use it. 10 years free this year, baby. Thankful I'm alive. We are thankful that you're alive too, Cheryl. You are one of just many of the warriors in the chat. Wendy, thank you for the 10. I like Taylor, but he seems to leave a lot on the table that he should fight for, like he's forgotten some elements of the event. Ashley's not capable of assisting him, and he needs help. I'm worried. I think he's been doing a really good job, Wendy, I got to say. let's wait until after we hear his closing and we'll see if he tied everything up properly. How about that? Sound fair? That is right. Wendy, darling, it's from Peter Pan. I love it. I saw Peter Pan on Broadway with Sandy Duncan. Do you remember Sandy Duncan? When I was a kid, and it was pretty awesome. Peter Pan. Everybody knows Wendy, darling. Or are we just dating ourselves? Awesome. Becker, thank you for your super chat. To what limit can and will the judge instruct the jury? Please, Melanie. UK and a bit confused here. Well, they're just talking about the jury instructions that they want the judge to give the jury, and that's always open for argument, collaboration, discussion. And so we are going to hear the jury instructions before the jury is sent out to deliberate. It's hard for us to talk about them when we can't see exactly what they're talking about, but I have some pulled up that we can look at when they're done with their discussion. So thanks for that. Okay, that was Wendy. I already put these up, but Midnight Moon, thank you so much for your super chat. As a psychotherapist, many times I have to educate clients that they are being abused when it's not physical. Survivors don't always realize, and that's true. That's a great point. I'm sure you're an excellent therapist. Kathy, thanks for the 5. My grandson is a power lifter. When he's in street clothes, you would never know it. He looks completely non-threatening, but mess around and find out. Great point about that boat picture. And look at Laura, the badass. Powerlifting in high school. She was 123 pounds and she could lift over 380 pounds. That is right. You are a badass, Laura. Dobie Mom says the dark-haired prosecutor even has Cruella de Vil gray hair streak. I noticed that too. Thanks, Dobie Mom, for the super chat.
Rather than committed an act of violence, we would request that it read had committed acts of violence. You may consider rather than that, this. Based on the evidence, there's obviously more than one act.
All right.
Where exactly? No, right.
As you said, the penultimate paragraph, the next to last paragraph, and it says Doug Benefield had committed an act of violence. They want it to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right. Well, so do you want it to say an act or acts or just committed acts?
Acts, A-C-T-S, acts of violence, and you may consider this rather than that.
It's that fact in determining.
You wanted to say this fact instead of that fact?
Correct.
Okay. I don't know.
Plural as opposed to singular.
Sure.
That's fine, Judge.
All right. Anything else on 3.6F?
No.
State?
No,
Okay.
thank you.
3.7, any objection? It's got some horrible. Sir, you're not writing down each sniffle, are you?
No snuffles.
Okay, thank you.
It's a lot.
He said, you're not writing down each sniffle, are you? To the court reporter.
Sentence missing. Judge, I think there's a sentence missing on this one. Proof beyond a reasonable doubt does not mean proof beyond all doubt.
Where is that at?
It would come right before a reasonable doubt is not a mere possible doubt.
I guess I'm in good company, Elf, huh?
I'm looking at the 3.7.
Which paragraph are you on? I'm sorry. Oh, okay, I found it. Oh, that's an update since 2024. There is an update.
Is that the only update?
Yes, that's the only request that I have as to that instruction.
Well, looking at that one, they've also added,
I'm still,
is this one of the ones that just came out in May or July?
obviously our system has not been updated.
So if you look at the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too? It also has an addition. See right in the, about a third of the way down, the defendant is not required to present evidence or prove anything, which is what we've always had,
Right.
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that applies.
Do you want to make an argument for or against defense?
Brandon says, I don't think the state even gave a rebuttal. They called one witness this morning. If you weren't here, they called Eva and asked her like 3 or 4 questions and asked her about some photographs or just a photograph. And really that was it.
Judge, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
Okay. I just didn't want to be rude.
You didn't want to be rude? Oh, starting now? Sorry. Sometimes we have to make jokes because, we just have to make jokes. Listen, there's nothing funny about this at all on either side, on any side. But let's try and, this chat is one of the wittiest chats on the internet. So I'll allow it. If you want to make some jokes about other things that don't have to do with about the tragedy in this case, I'll allow it. Go forth and prosper. Guide your actions accordingly.
Yeah, so, it's interesting, Judge, because self-defense is an affirmative defense, but yet in the instruction, they don't acknowledge that. They just limit the instruction, whereas a suggestion, insanity, reunification of an attempt, or rather renunciation of an attempt. No, I think that's confusing. I wouldn't request that.
Samantha, Eva's mom, Renee, was Doug's second wife.
This is interesting. I'm not even aware of any case law interpreting this edition yet. Because it's interesting, in state, I'm just going to throw this out there. So certainly it's an accurate statement of the law. I think we can all agree on that, right? State has to prove beyond well, first it's a prima facie case, but proof beyond a reasonable doubt. Then there's the preponderance of the evidence that an affirmative defense, and the defendant has the burden of production and persuasion on it, but then the burden shifts back for the state to prove beyond a reasonable doubt the defendant did not act in. So it's interesting because this addition says the defendant not required to present evidence or prove anything except for the defense of, but then doesn't talk about that burden shifting. I don't know. I wasn't on the committee. I'm on a different committee, so I don't know how I understand explaining, well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more likely than not, greater weight of the evidence, whatever words they wanted to use. But then the burden shifts back to the state to prove beyond a reasonable doubt the defendant's not entitled. So do you want to be heard?
Yes, I think that we're asking for it. I think insanity and renunciation of attempt are examples. It says e.g. So I think it's well established that self-defense is an affirmative defense, and I don't know what legally would prevent it from being included in this instruction. And I think it is, as Your Honor has already said, an accurate statement of law. So we are asking for that paragraph to be included.
15 years, Ashley,
Not
15
that
years.
this isn't difficult enough, but if the court does decide to add that, I think the court, in fairness, would be required to elaborate on the burden shifting back to the state, as the court just acknowledged.
All right. Thank you both very much. Here's, and certainly, whenever, after I read the instructions and I charge the jury, I'll obviously ask if you have any objections to how the jury was charged. If it's just all the same previous objections, just renew your objections. Here's the reason I hesitate to give this right now. It's brand new.
Okay. This is the woman in the courtroom that Jules told us was like a good friend of Ashley's for like 9 years. Is Ashley's mom in the courtroom now? I don't know. And so she is there for moral support. She's a friend of Ashley's for something like 9 years. Somebody asked, why do they wait until now to do the jury instructions? The reason is because they have to wait for all the evidence to come in. They can't really talk about the jury instructions until they know what all the evidence is. And therefore, they know how to instruct the jury. And that is why it is done now before closing arguments.
And I could be wrong, but I do have some concerns about how truncated it is with the actual nuances of the burden shifting that goes along with affirmative defenses and not explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt, and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law on how this instruction is going to work now. So I'm going to leave it at the defendant is not required to present evidence or prove anything. You added in that additional sentence, proof beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, Chris. So you're going to put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the.
I printed out a new one for
Perfect.
her, yes.
Any other changes?
No, sir.
State? 3.7 good?
No, nothing else.
Except for the objections about.
Yes.
Yeah. That'll be interesting to see how that plays out. All right, 3.9.
No objection.
All right, perfect. Again, that's where I'm going to stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
3.11?
No.
3.12?
No.
3.13?
No.
During that same paragraph, I talked. I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech cart that's right out here in the hallway. And when they go back to deliberate, they can play is it just the 911 call? Is that the only thing that's in?
Well, but there is a DVD of text messages if they wanted to,
All right.
read
They
them.
have a computer back there that has no access to the internet. It's just a laptop that is on the tech cart that they can use to view items or listen to items. So I do go off script there to tell them that. Also, up a couple of paragraphs from there, when I talk about the cell phones have to be, and electronic devices have to be left out. I also talk about smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the deputy. All right, and then the verdict form.
No objection.
On the manslaughter, I thought the manslaughter was just,
We were just talking about that.
yeah, I think the manslaughter might need to be,
Sometimes we,
it's just one question.
Well, yeah. You mean breaking the questions up? I think
Right.
the state, this is the jury instruction we've been using because I think that it is confusing I think it puts too much emphasis on the separate charges if you break them up. And I think if they checked manslaughter and then 1, 2, and 3, there's no harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between, obviously, the second-degree murder and the manslaughter for the sentencing enhancements and the 10-20 life.
Yeah, I don't have a problem.
You're okay with this one? All right, there we go. Not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so that'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here and we can get started.
is there going to be a long J-way argument? And if so, when do we want to do that?
Did you want to make one now, or do you want to wait until after we let the jury go?
You have to let the jury go.
All right. So the reserve on that. All right, y'all. We'll see you back in a little bit.
Thank you.
Okay. We have a little bit of time to talk, and then they will be coming back at 12:30 to do closing arguments. Very exciting. Quickest trial in history that we've watched in a very, very long time. I don't think he's going to do anything else right now. Let me just fast forward. We were a little bit behind. We can FF and talk amongst ourselves for a little while. Let's do that, shall we? Space Kitty, thanks for the 5. My ex is in prison for 22 years for strangling me and beating my head repeatedly with a sledgehammer. Oh my God, I just can't even read that out loud. It upsets me so much. He did it when you attempted to leave. Oh my God, that is horrifying. I'm so sorry. I'm sending you a million hugs. Lynn, thank you so much for the $20 super sticker. Ashley, thank you so much for the 5. Says, I bought you a coffee and left a note about my own experience. Love and peace to all. Here's a reminder to show grace and empathy. Thank you for the coffee, Ashley, and for sharing your experience with everyone else in the chat. And Ashley also became a member. Welcome. We're so happy to have you. Susan, I put this up before, but thanks for the 10. Those who don't know. My ex was a black belt in judo, and to hurt me, he had my 12-year-old son in a chokehold. I begged him to K me instead. When police came, they just let my ex walk out. That's horrifying. On top, thank you so much for your super sticker. Let's take a look. At some of the jury instructions. So it looks like she's going to also they're going to include not only murder in the second degree, but also manslaughter and aggravated manslaughter. So let's take a look at some of these jury instructions so we have an idea of what they're talking about. Give me 1 second to pull it up. Okay, second degree murder, 7.4. Okay. This is murder in the second degree. This is the pattern jury instruction, so the final one may differ a little bit from what we're going to see here. This is the pattern jury instruction for murder in the second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Doug Benefield is dead. Number 2, the death was caused by the criminal act of Ashley Benefield. Number 3, there was an unlawful killing of Doug Benefield by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Definitions. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do seriously bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. And then there's an additional heat of passion argument, and I can't remember if that was in or out. But I'll read it to you. An issue in this case is whether Ashley Benefield did not have a depraved mind without regard to human life because she acted in the heat of passion based on adequate provocation. I don't recall. Does anybody recall whether this is in or out? So don't hold me to it. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Ashley Benefield was in fact so provoked and did not cool off before she committed the act that caused the death of Douglas Benefield. If you have reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find him or her guilty of second-degree murder. If you find Ashley Benefield guilty of second-degree murder, you must also determine whether the state proved beyond a reasonable doubt that she actually killed him. Here's where I think they might be hung up on this one. Whether or not the act was done from, number 2, ill will, hatred, spite, or an evil intent. And that's where they're going to be able to consider self-defense as an offense. I don't think heat of passion is going to be in there now that I think about it. And so here are the lesser included offenses. So if they find not guilty of second degree, here are the lesser included. So they're going to charge 7.7 manslaughter and aggravated manslaughter. So let's take a look at that. Here's the charge on manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number 1, Doug Benefield is dead. Number 2, Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. In order to convict manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. And then there's a charge for aggravated manslaughter, which is here. To prove the crime of aggravated manslaughter, the state must prove the following three elements beyond a reasonable doubt. Number 1, Doug Benefield is dead. Number 2, the death of Doug Benefield was caused by the culpable negligence of Ashley Benefield. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. And then that goes on a little bit. I'm not sure if that was tweaked a little bit, so I don't want to get everyone confused. But in addition to that, I just want to take a look and show you the instruction for stand your ground, which is the self-defense instruction. Talk amongst yourselves for a second. Do 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 do. And why can I not find it right now? I know why, because I'm on the air. I can find it when I'm not on the air in about 2 seconds. Maxie Doodle has full faith in this jury. There will only be 6 members of the jury deliberating. There are 9 on the panel, 7 women, 2 men. The youngest is a male in his 40s, and the women, I believe, are in their 60s, 70s, and 80s. And that is what Jules told us. Well, rather than waste too much time trying to find this now, I'm going to have to find this later, and we can talk about it when we come back later. Thanks, VKaser, and is throwing up hearts for those in the chat who've been hurt. And thank you to Anita, who became a new member. Thank you so very, very, very much. Swift verdict in this case is good for Ashley. If it drags on, they're going for a lesser charge. That may be true. That may be true. I mean, I wonder what's the over-under, you guys, on whether you think, how long you think it's going to take. I'm going to pull these up from the judge's order. See, these may be a little bit different now than what he wrote in his order, but it's a good place to start anyway to take a look at this. So many of you have been asking about the stand your ground law, so let's take a look at that here. Here are the substantive aspects of Florida's stand your ground law. Ashley Benefield would be justified in using deadly force against Doug Benefield if she reasonably believed that using such force was necessary to prevent imminent death or great bodily harm to herself or prevent the imminent commission of a forcible felony. And that's why they were talking about those other felonies earlier, about the false imprisonment, the aggravated assault, the burglary. If Ashley Benefield used deadly force in accordance with this subsection, she did not have a duty to retreat and had the right to stand her ground if she was not engaged in criminal activity and was in a place where she had the right to be. Home protection, use of deadly force. If Ashley Benefield was in a dwelling or residence in which she had the right to be, she had no duty to retreat and had the right to stand her ground and use deadly force if she reasonably believed that using such force was necessary to prevent imminent death or great bodily harm to herself or prevent the imminent commission of a forcible felony. In my opinion, that's what it's going to come down to. Whether Ashley Benefield reasonably believed that she was in danger or she was in fear of imminent death or bodily or great bodily harm. What say you? And if she believed that, she was justified in using deadly force, in which case, if the jury had any reasonable doubt about that, they would have to acquit her under the law. Ashley says, I think it'll be fast. I'm glad there's no weekend. Laura says, smaller women victimize larger men all the time. This is true. Sarah in shock and horror gifted 10 memberships. Thank you, Sarah. You're so kind and generous. So sweet. Thank you. And to all of you who were randomly selected by YouTube to receive those memberships, welcome, welcome, welcome. Mistrial. Question. Burden is on the state to prove Ashley was not justified in her use of deadly force, right? Yep. Defense doesn't have to prove she was justified, right? Yep. Seems like a small difference, but it's actually huge. Yep. The burden shifts to the prosecution to show that she was not justified and that the threat was not reasonable. Emma says, remember, no matter personal beliefs, the verdict has to come from the state proving their case and disproving the self-defense claims. I do not believe they did that. The verdict has to come from the state. Yeah, the verdict. The jury has to believe that the state proved their case, exactly. And if they have any reasonable doubt, then they must acquit. Salem Sphinx said Ashley probably thought Doug would behave knowing her mom and their daughter were coming right back. That's another great point. Glitter Beauty says, I'm very nervous that most of the jury is made up of women because most of the vitriol I've seen online is from women. You are so right. The same here. I have seen the same. And I wonder if knowing that the women are in their 60s, 70s, and 80s changes your opinion at all, or anybody in the chat. I would love to hear from you on that. So many people think or have said that older women have been through it all. They know, they can understand. And some have said some older women are from a generation where it was just, you just put up with it and you don't say anything. So there's a split of opinion on that. And I wonder what you guys think about the age of the women and whether that will have anything to do with their understanding and their sympathy for Ashley and their, her believability, credibility. how come they don't allow all evidence in trials? Just my opinion. But if the jury had all the evidence, they can make their decision knowing they've seen everything. No, because there's rules of procedure and what's allowed in and what isn't, and what could be more prejudicial than probative. And those are, decisions that the judge makes. They're not always correct, but there are rules. Alyssa, speaking of Karen Reed, DeGlara mentioned you last night and officially invited you on the show. Oh, that's great. It's just too hard for me to go on anybody's show like in the middle of covering a live trial because this is so exhausting. But as soon as this trial's over, maybe sometime next week, if he wants to invite me on, I'm happy to go and talk about Karen Reed. That would be amazing. So I'm sure that we will be in touch and talk about that then. Thank you for pointing that out to me. How come they can't do jury instructions before this time? I think we touched on that. They have to wait until all the evidence is in before they decide how to instruct the jury. Sandy B, her attorney needs to point out the state didn't call their lead detective. I think he's going to point that out in his closing. At least I would hope that he did, that he will. Set up the afternoon stream for us here. Christina, thanks for coming in. In our 70s means we grew up in the 60s and 70s, the first generation that started questioning peace and love over war and prejudice. That's great. That's a great point. I'm sure there's going to be a Netflix movie or documentary about Karen soon. Yeah, Netflix, the deal was greenlit on Netflix, and there are a couple of things also already in the works. I think somebody said Karen may have a deal and Aiden may have a deal too. I don't know who's producing them or what they're going to be about. But the Netflix docuseries was greenlit. That was in Deadline, I think, last week. Farmer says, I don't think women liked putting up with it then and won't tolerate it today, but I'm not a woman, so I don't even want to act like I know what goes on in their minds. Vanessa says, I don't understand the logic with those that think she's guilty. If there's anybody in here, I would love to hear from you. Court's on a break because they have finalized jury instructions and the attorneys are going back to work on their closings, and they are going to be coming back at 12:30 with closing arguments to round out the afternoon. And they've each been given an hour and a half. And they said they probably will not each use an hour and a half, but that's how much time they've been allotted. And so it will be a very, very interesting afternoon. Ashley, you are very welcome for creating this space. I'm so glad that so many of you have found me, us, and this chat. Wolfie Muse said if she didn't testify, still not guilty, the state didn't prove beyond a reasonable doubt, in my opinion. I mean, think of all the evidence that was let in, right? About their relationship, all those controlling text messages and the incidents of him abusing the pets, punching the dog in the head until he was rendered unconscious, throwing the cat down the stairs a couple of times, punching holes in walls, shooting the gun into the ceiling, throwing a loaded gun at her. And people who think that she's guilty say, well, he never hit her before, so. And I guess that's a position. Jamie says, I fear the lesser included split the baby. Yeah, the lead investigator did not testify. They called him in on the defense's case in chief. If you didn't see that, it was good testimony. Exactly, Shaylee. It's crazy they get an hour and a half when Alan Jackson got only an hour for a 10-week trial. Isn't that crazy? So crazy. There was so much more to talk about in the Karen Reed closings that the fact that they only got an hour was mind-numbing to me. and completely, I thought they absolutely needed more time. I thought they needed to address the jury instructions in their closing. They needed to go through the verdict sheet in their closing and explain it better to the jury. And I think it needed to be pointed out that if you find that John O'Keefe was not hit by Karen Reed's car, that's the end. You're done. Not guilty. I just think that needed to be hammered home more. And I think that 1 hour was not enough at all, in my opinion. DK, thank you so much for coming in with a $50 super chat. What decade did we go back to when DV victims are not believed and are minimized? I'm still so disgusted by the dismissive attitude by the prosecutor. You can't give a pass to the abusive beast. Stand strong, my victim, survivor, brother and sisters. You're so sweet, Dee, and I've heard your story, and you've told your story openly, and I'm horrified about the things you had to go through, and you're so compassionate to all of the other survivors and victims here. And thank you so much. There's an anonymous matcha who says, my late partner and I were together for 12 years. The last 2 months were very rocky, but he was never violent. 3 days after I moved out, he committed a M/S, if you know, you know. So he took someone else's life and then took his own life. Abuse looks different on everybody. You'd never know by interacting with me the anguish I still feel 1.5 years later, still loving him, but being angry and grief-stricken and dealing with the PTSD he left me and our kids with. It was only one act of violence and it traumatized me. I wish people would stop judging others on how they cope with their abuse. It's not always physical and it looks different for everyone. And that is a tragic, heartbreaking story. And thank you, Barbara, for your very generous Venmo. Coffee and lunch for you and Jules. Made it through neck surgery. I couldn't watch yesterday, so I'm catching up. Hope to go home tomorrow. Neck surgery is terrible. Oh, Barbara, I'm so glad that maybe we can entertain you in your recuperation. But yes, it is a very, very difficult recovery. We're sending you all the healing vibes. Everyone send Barbara some healing vibes, please. That is a very, very difficult and hard surgery to recover from. It's a long recovery, but we wish you all the best. Sending you 1,000 hugs. And Sierra, thank you so much for the Cash App saying that we've created a safe space. And she also has suffered trauma. And I'm sorry about that, Sierra. So sorry. James, I think I already did it. Thank you. But thank you again for your Cash App. Okay, my friends, what we are going to do is we are going to break right now until 12:10. And we are going to come back at 12:10. Closings are going to be at 12:30. Virginia, thank you so much for being a member for 4 months. Norfolk County District Attorney's Office is ignoring the jurors' calls. Really? Yes, I saw that. I saw that one of the jurors that reached out to that reporter, Christina Rex, tried calling the DA's office and they're not calling him back. Susan, thank you for the 10. The fear when someone wants to kill you instead of being with you is real terror. I had to beg for my life as my ex was driving 80 miles an hour toward a divide on the highway. That's heartbreaking. Experienced that. And then the judge. I'm so sorry, Susan. Becky's Blue-Eyed Paranormal says, can the prosecution object through closings? They can. They can object. It's an argument, so there's not that much stuff that's objectionable. But they can object if you're closing on something that never came into evidence or you're just whipping out a new theory. Never a good look, but yes, it is permitted. Kathy, thanks for the 5. Thinking about why women are other women's harshest critics. What I do know is that happy and confident women don't do that. It's a great point, Kathy. I point it out all the time. I don't get it either. I don't know. Who was it that said there's a special place in hell for women who don't support other women? I don't know. Eleanor Roosevelt or something like that. I can't recall. All right. So we're going to come back at 12:10. Everybody go take a break, take a breather, deep breaths. And then we're going to come back. We're going to talk about all of this later. I think I set it up for 12:10. I'm going to teleport you to the other stream. So hang on. Safe travels. Thank you to the moderators for keeping it classy. It wasn't that long this morning, so hopefully it wasn't too terrible. Be cool, be kind, be classy. I'll see you at 12:10. Peace. No, this way. Sorry, the other way is not a good thing apparently in the UK. So this way is the peace sign. See you over there. Safe travels, my friends. Be cool, be kind, be classy. Not hard. So not hard. See you on the other side.